All right, before I begin, can everyone hear me?
Yes, Your Honor.
Yes, Your Honor.
Fantastic. Court will come into session on the 12th of January 2025 at 8:20 p.m. Australian Eastern Daylight Time. The case of Warden. Sorry, can I hear me?
I can hear you.
No, it's a little bit quiet.
It's a bit quiet.
You're a bit quiet. Turn up your voice box. If you press your con, make sure it's on max. And...
Okay.
Perfect. I hear you now. Court come into session on the 12th of January 2025 at 8:20 p.m. Australian Eastern Daylight Time of the case of Warner v. the Los Santos PD Department. Could the plaintiff please approach the stand?
Is that me?
Oh,
No. Now, to the plaintiff, just confirm you have attempted to reach a settlement offer in this case before we proceed.
Yes, Your Honor, we have.
No worries. And any motions to strike any forms of evidence before we proceed to opening statements?
Your Honor, no evidence from the defense side has been presented to us, and our only evidence that we are presenting, as I said, are going to be testimonies.
Very well, you may go back to your desk. Could the defense please approach the stand?
Yes, Your Honor.
Do you wish to proceed to strike any forms of evidence in this case?
What? What does that mean?
All right, given the fact there is no evidence submitted, you may go back to your desk.
Oh, too easy.
Could the plaintiff please approach the stand and begin with their opening statement?
Yes, Your Honor. To the Honourables, thanks for your time. Today is a pretty interesting case I'm bringing you guys. Today, my client was arrested under without probable cause or reasonable suspicion by the officer. He was during this arrest process. He had a gun pointed at his head, despite my client having no reason to have any aggression against the officer. No firearm was present, no knife, no verbal action. The officer threatened my client's life by the gun pointed at him, and arrested him and charged him with attempted murder without any legal basis. Despite the brief plea agreement during the cells, where he agreed to drop the charges due to the lack of evidence admitted on his part, and the evidence that we had on ours, my client then chose to file a suit against him due to the fact he was arrested without probable cause or reasonable suspicion, and due to the fact he was scared for his life. During this trial, we will call multiple witnesses, one being a medical professional who can confirm that my client is now in the early stages of PTSD due to the interactions he's had with the police department. This has affected him mentally, and he has been recommended, and he will give his recommendations regarding medical treatment further, which will need to be paid for. We also bring other witnesses, one being a police officer who was right in the cells when I was negotiating a plea agreement. The officer will be able to testify, unless he just chooses to perjure himself, the fact that he overheard the defendant himself, claim when I said that we'll bring a suit, that he said he was going to, and I quote, stack the charges. That is malicious prosecution and very malicious against my poor client, who has already suffered a great deal from the police department. Obviously, we hope to find you find in our favor, and we hope to bring justice to the people of Los Santos by having better and safer streets. Thank you, Your Honor. That's all.
He's cooked.
Thank you to the plaintiff. Could the defense please approach the stand and begin with their opening statement?
What do I say now? Sorry.
A brief overview of your side, essentially.
So, when I did arrest old mate over there, that was after he jumped out of a white local vehicle, running up to me, tried to punch me, mate, after 3 other individuals started bashing me with crowbars. To the... Oh, what the fuck? That's not opening statement, sorry. Except for... I did not use a gun. I used a taser, because I was scared for my life, to ask him to put his hands up and place him under arrest. Once under arrest, I took him back to station. And obviously, he wished to go to court. Which I said, it's obviously going to be like, now it is. He said, she said. I'll just let him go free, because court will just be no good, yeah? And now he's saying this was held against his will, which he was the one that wanted to go to court all of a sudden. And yeah, all good. Thanks.
Thank you to the plaintiff. Now, as we have got 0 submissions of evidence, we'll proceed straight to witness examinations. Could the plaintiff please weigh their first witness in this affair?
Yes, Your Honor. The plaintiff calls Knox Riker to the stand.
Very well. Could Knox Riker please approach the witness stand?
That's the stand over.
Just over here. Just take a seat here. I know there's a computer and everything, but just leave it as it. Can I have you please flex a valid form of government issued identification for the record? No worries. Mr. Knox Riker, do you swear you'll tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. To the examiner-in-chief, you have the floor.
Thank you, Your Honor. So, could you just, for the record, state your name and occupation? Hello? Hello?
Yeah.
Could you state your name and record for the name and occupation for the record?
Yeah. Knox Riker, my rank, EMT.
Could you explain a little bit your background and your qualification and why you are here today?
Sorry, you're cutting in and out there, sir.
Was that better?
Is anyone else able to hear the gentleman?
Hello? Is everyone else
Yeah, I
hearing?
can hear.
I'm able to hear
Now I
both
can.
individuals.
Okay.
To Mr. Riker, you confirm that you are on
My God.
shouts.
I think there might be issues
Confirm what,
with that
sorry? I
seat.
might stand
You're
over
on
here, I can hear better.
That you're on shout.
You're on the highest level of volume?
Yeah.
Okay. Okay. Well, is that fine? We can sort of hear? Are we standing?
Yep, that's
Okay. Could you just explain why you're here today and what sort of qualifications you have to give a mental health evaluation?
I was asked to come in and evaluate the plaintiff on his current condition, and how that may evolve, and as per its situation and my qualifications, I've been an EMT in this city since flights were opened up and we're allowed to fly in, and my previous history is 22 years in the US Coast Guard as a naval rescue swimmer, and we were highly trained in evaluating trauma, mental stress on scene, and with other members of the team. Obviously, last thing we need is people going into panic at any point in time when we're handling those type of machinery, and lives are in everyone's hands. So,
During your evaluation, could you just tell us what your evaluation of him as this person's current mental state and any recommendations that you had given?
yeah, at this point in time, the plaintiff was showing severe signs of trauma based on what he told me he'd been through. I noticed him being jumpy and jittery around certain sounds that he admitted, although I did question him further to find out whether or not it had further divulged into a deeper condition. At this point in time, I don't believe it has, but it is definitely showing signs of him, I guess, if he doesn't get it treated, if he doesn't come and speak to someone about it, doesn't come in and talk to a doctor or a therapist, he could find himself suffering severe PTSD further down the road. And that can happen to anyone based on any incident, as little as putting their finger in a mousetrap. So, yeah, at this point in time, it's a little bit early to say whether that may or may not happen. But my recommendation would be that he does seek further medical assessment, at least twice in the next 30 days at minimum, so we can at least either prevent or try and deter him from spiraling. At this time, though, I mean, the incident was recent, so as anyone would be still pretty close to showing shock and trauma from that incident. But yeah, that was all I knew from the facts. So I don't know exactly what he's been through, detail after detail. But
what sort of sounds did you think? Did you say he was scared of? Jumpy about.
I did well, he told me a certain number of sounds, but that's irrelevant what he told me, because that's just hearsay. But I did witness him jumping and taking cover to sirens, and they were just medic sirens when the ambulance was pulling up at the courthouse. And I was actually quite surprised by that so soon.
Did the ambulance sirens have a similar sound to the police sirens?
Fortunately, in this city, where our sirens are exactly the same,
so that could be linked.
Yeah,
okay,
it could definitely be identified as police cars. Yeah.
Unless my co-counsel has any questions. Other questions?
No questions here.
The plaintiff rests on this side. This witness, Your Honor.
Very well. To the defence, you may begin your cross-examination.
Hey, mate. So, as you said, he got PTSD from the sounds of EMS and police sirens. How would this
no, he's just
be...
reacting to him. He definitely doesn't have PTSD just from sirens.
Yeah, but you said he was jumpy and jittery from certain noises.
Yeah, absolutely. Yep.
How would this relay back to me from police sirens?
Objection. Calls for speculation.
Sustained.
What does that mean? Also, because I don't really just see how police sirens is kind of my fault and how it's been.
Objection. He's
against.
testifying.
Sustained.
I'm just like, nah, all good then, all good.
All right. Does the prosecution rest?
Yes, on this witness, Your Honor, we do. We have more witnesses though.
Defence, do you rest?
So was the sounds he was jumping jittery only to the police siren?
Just to hearing sirens at this point.
Just sirens, that's it.
Yeah, or he just heard sirens and he jumped to them. I mean, just to answer your question, you're sort of I could see where you're leading. So
yeah, objection.
I'll just
This is a leading question.
I'm just asking, is it from the sirens? Is there any other cause of why he's jumping and jittering and got PTSD from it?
I will allow this. The court will note the objection. You may continue.
Yeah, so I was called in to evaluate the client and basically his situation. And the fact that he's jumping to sirens doesn't reflect on you at all. So that's not going to be, that has nothing to do with you anyway, even though you are curious about that. So if that's where you're trying to lead to, it's not against you. So I mean, anyone can be scared of sirens. You hear babies scream all the time and cry when they hear sirens going off. So it's just a startle effect. It doesn't mean if that's what you're trying to that's what you're trying to ask me. If I could see where you're going with it. Can anyone be scared of sirens? What has that got to do with the situation at hand? You mean, like,
yeah?
Why could the client have been scared of sirens for other reasons? Absolutely, yes. If that answers what you were trying to ask me.
Yeah, thank you. No other further questions.
I can see you having trouble trying to get to where you're trying to go. So
Very well, the witness may be excused.
Thank you.
No worries.
Won't be
Court
need for
appreciates your
recall. I
input
can head
and
back on
time.
duty.
That's correct.
No
Thank
worries.
you, Your Honour.
gentlemen.
Thanks, Knox. Appreciate your time and effort.
Appreciate it, guys.
I believe the prosecution has another witness to call.
We have a few. The prosecution calls Timmy Terror to the stand.
Just confirm that's Timmy Terror.
Yes, Terror.
Very well. You may take a seat in the witness chair.
Oh, wait, you probably have the same problem the other guy did, but yeah, okay.
All right. Mr. Terror, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Fantastic. The examiner-in-chief, you have the floor.
Just confirming you can hear me, correct, Timmy?
Yep.
Okay. For your name and name for the record.
Timmy Terror.
Cool. Timmy, could you explain from your part the situation that led to you interacting, seeing this officer for the first time, and then your friend James being arrested?
You want to start like when we rocked up first, then when
Yep.
we rocked up second?
But the whole thing.
So we heard gunshots while we were driving around the city, and then we were driving around looking for it, and we see like some person on the ground, just laying there. Did not see anyone else. We went up. James himself jumped out of the vehicle and went up to the guy to pick him up, so we can get him to the EMS, the hospital. And I drove them to the hospital. Then on our way back, we went back to see if we could find anyone else. And then we saw a cop and an EMS. I think the EMS was giving the cops CPR. So we pulled over, pulled into the driveway. James jumps out of the vehicle to talk to the police officer. The police officer fully pulls out his taser, it looked like first, and then pulled out his lethal and started screaming to put his hands up, puts his hands up. And there was a second officer vehicle that pulled up after sometime before that, or after that, sorry. And I was just talking to him, and he told me to he should be detained and questioned. And I get a phone call after saying James is locked up and he's going to prison.
And that phone call was, how was James?
He was scared. He was basically shivering and fucking like crying on the phone. I can hear him fucking like, oh, sorry, Your Honor, for my language, but he sounded like he was about to cry.
Okay. You say that the officer was getting CPR. So there was the officer was on the ground being CPR as you drove up.
It looked like he was getting on his feet at the time.
Yeah.
When we drove up, then we pulled over, and then James just jumped out, and that's where it escalated.
Yeah. And just for confirmation, due to the fact of the original arrest, you guys obviously, you can testify the fact that you two, or as you as the driver, did not run over this officer at any point in your vehicle.
Yeah. I was like parked, I'll say 2 buses away, or like a bus and a half away on the side of the road. And we did not see anyone else at that time.
Did James have any firearm, knife, or anything like that, or anything especially visible when he got the vehicle?
No, he did have a hunting knife, but he did not show that at all. It was secured in his hunting knife pouch.
So if you didn't know who James was and you saw him coming up to you, would have you been threatened?
No.
Unless my co-counsel has any further questions?
Not at this point.
No further questions for now, Your Honor.
Very well. For the defense, please move to the cross-examination.
Where'd the bad bitch go?
To the police officer, can you just go back and shout for me, please?
What?
I'm just having a little think what to ask him, sorry.
No, you're fine.
I need the fish.
Yeah, no question.
I am broken. Oh, my bad. I'm broken.
just gonna. Could the two people in the gallery please stop fighting in my
I'm trying to
courtroom?
fish myself and I accidentally punched him.
Oh, actually,
Any more
Gage
shenanigans,
muscle
I will
game.
be charged
Hey,
with
mate,
both
so,
of being
Gage
contempt of
muscle.
my court.
I did.
when you said you saw me pull out a taser and then my lethal weapon, how were you able to see that when you were was it one or two buses away?
No, that was after we pulled up when you again EMS treated you. If you remembered, we pulled up in the not garage, or like in front of the garage in the driveway, like say half a police car. When James jumped out and you
So
pointed
it
to,
went from one bus to half a police car.
no,
Objection, Your Honor. This is not. This is a different situation, which the witness is clearly testifying to, not the same situation.
Oh, sorry, mate.
like I said earlier, you pulled out
I'm just
two
going to interject.
sort of. Yep.
I'm going to allow this, however, the court will make note of the
You
objection
punched me,
made.
bitch.
I want to hear the answer.
As I said, you pulled out a thing to what seemed like a taser or a firearm of some sort, and then you pulled out a second one. You put away your first one and pulled out the second one. I did not see what it was because I was more fucking. Oh, sorry, Your Honor, for the language, but I was more scared you're gonna shoot and I'm gonna get shot in the back of the head in the vehicle.
Was this on the first or the second time?
Second, when we pulled up.
No further questions, Your Honor.
A rebound question, if you're allowed, Honor.
Yes, you may move to redirect, plaintiff.
Damn, we got that rebound.
Just question. When you said you originally pulled up, you said you heard gunshots, correct?
The first time, yes. Like
Did you
when
see?
we first...
Did you see anyone else that would have had a firearm or had the ability to shoot any bullets?
No.
And did you have a conversation with the guy you took to hospital? And if so, what did he say when you were speaking to him and you and James earlier, when you took him to the hospital?
Objection.
I cannot.
That is sustained.
On what grounds?
Here, sir.
How would the guy be talking about that?
Yes.
Because at the
that's correct.
hospital, when they took him to the hospital and then make sure
Yeah,
he was
but
okay.
how would he remember anything?
Maybe he wasn't taken off. Maybe he was still alive. Maybe he was injured.
If he was still alive, why was he taken to the hospital?
The court members,
No, good. All good.
attorneys only address the judge, not between each other for a start. And secondly,
Your Honor.
all mentions to what has previously been counted will be stricken off the record, and the plaintiff may continue.
Okay. But just correct, brief. I mean, you did hear gunshots when you
Yeah.
arrived. Okay. And did you when you arrived the second time? Did you see anyone else with a firearm other than the officer?
No. All I saw was an EMS and the officer.
Okay. And regarding the guy you took to hospital, did he look like shot at, or was he just unconscious on the ground?
He was like in a fetal position, like a little bit of a fetal position.
Was there any blood around him?
Not what I saw.
So there could have been blood.
I did not see any blood.
Okay. No further questions, Your Honor.
Very well.
I still have one more question.
Yes, the defense
So
may
when you
move to
arrived on
redirect.
scene for the second time, where did you see me?
You were between two vehicles. I think it was a black. I don't know the brand, but it was a black 4-door, and I don't know the other vehicle. But
No, all good. And was I dead or alive?
all I saw was you getting up when we pulled up. Like you were getting on your feet by the EMS. The EMS was helping you up.
Yeah, no further questions.
Very well. Is that all, plaintiffs?
Yes, that's all for this question. We've still got further witness.
Anything. All right, the witness may be excused. Mr. Terror, the court appreciates your time and your input in this affair. You may leave this courtroom. The prosecution, I believe you have another witness that you bring forth to this court.
Yes, Your Honor. The prosecution calls Senior Officer Gary McGee to the stand.
Very well. Could you please approach to the witness stand?
Cop going on a cop is crazy, by the way.
He's
well,
required
I'm
to.
forced to, idiot.
All right. Could you please flex a form of government issue
Oh,
identification?
frick yeah.
No worry. Mr. Gary McGee, do you swear you tell the truth, the whole truth, and nothing but the truth, so help
Yes.
you God?
So help me God, I swear the truth.
Very well. The cross-examiner, you have the floor.
Thank you, Your Honor. Gary,
Hello.
just for the name of record, can you state your name and occupation and where you work?
Gary McGee, Senior Officer for the LSPD.
LSPD. Okay. On the earlier in the day today, were you in cells when I was speaking to you guys regarding plea agreement for the defendant? Oh, sorry, for the
Yes.
plaintiff. Sorry.
Yeah.
When we reached an agreement, then I said that there would be a suit. Could you reiterate exactly what the defendant said when I said I was going to be bringing a lawsuit against him?
I kinda don't remember that one.
Permission to prompt the witness, Your Honor.
If the witness doesn't remember, he doesn't have.
He didn't remember
any expectation.
exactly.
Objection.
Objecting to what?
Prompting the witness. No go. He said he doesn't remember.
If the witness doesn't remember the facts,
He said exactly. He didn't remember exactly.
you remember
I
exactly.
kinda
Doesn't
don't
remember.
remember.
Okay.
If that's
Other
the
than the
case,
fact he said he
cannot
would, he did
answer.
earlier. Or he did say earlier. I spoke to him in person. He claimed he did, and if he wants to purge himself.
Wait, can you repeat the question? I didn't.
Do you remember exactly what the defendant said when I said that I'd be bringing a lawsuit, and what he said regarding the charges?
I honestly do not remember.
Your Honor,
He
he's
said,
claimed
like,
it.
he said like friggin' no, what? Oh, okay, yes, he said he's gonna stack up them charges.
Thank you. As I said, Your Honor, obviously, clearly, he did tell me earlier he did remember what he said. So he said he was going to stack these charges. And what, in general, from as you as a police officer, you could speak to, what does exactly stack the charges generally mean?
We're going to court, so you're gonna stack them charges.
Yeah, but what does stack them charges mean?
Give him as much months.
So extra, okay. Do you remember? Do you, by any chance, remember how many months he said he was going to give the stack the charges?
90.
90. Your Honor, could we please enter the fact that the attempted murder charge is only 23 months? Can we get that acknowledged by court? That's the fact of the charge list.
Yes, that can be entered into the record.
Thank you. Gary, do you by any chance remember what exactly which charge he was being charged for initially?
No,
Okay.
because I wasn't the arresting. I wasn't even there
I
for
understand,
the
understand.
situation.
When he threatened to stack the charges, did you see that the defendant said it all seemed angry or aggravated?
No.
Is stacking the charges generally proper police procedure to stack the charge on every single client?
No.
Any questions, co-counsel? Defense arrest for the moment, you know. Oh, sorry,
Very well.
plaintiff.
What's that mean?
To the defense, do you wish to do you wish to cross-examine?
Yeah.
Hello.
Hey, Gary. Hey. So when I said I was going to stack the charges, was that on this court case or the original court case he said he would go to?
Objection, Your Honor. That's literally what the point of this case is about. Is about the original arrest.
He's not saying.
It was when he said you're
I'm going
take
to
the car.
overrule based on the fact individual testifying to this point, as you said, it is related to both cases. If these want clarification from witness, he's more than able to.
And Gary, you said it's not proper procedure to stack the charge.
Yes.
Whatever. Blah, blah, blah. And when does someone normally stack the charge?
When you're out of the car.
Yeah, no further questions, Your Honor.
The plaintiffs you wish to arrest,
No, Your Honor, I'm going to redirect.
you may proceed.
Gary, to the best of your knowledge, was a report created after the charges were dropped?
No.
So if there was, so there was no actual record to show that there was an arrest made due to the fact that the charges were dropped. Were the charges dropped initially?
What do you mean by that?
There was a plea grant made to drop the charges. Were those charges dropped?
Yes.
Other questions, Your Honor? To plaintiff arrests for this witness.
Very well. The witness, you may be excused. The court appreciates your time and input into this criminal matter.
Alright, time to go back on duty.
Thank you for your time, Gary.
Hello, Tay.
Very well. I believe, do you have any more witnesses to bring forward to this
The
court?
plaintiff calls Sam Prickling, the defendant, to the stand.
Now, the only issue that may arise is the fact that you might have someone to give questions during cross-examination.
I see that, Your Honor. But the fact
And
is, we
he
need to
is
decide
also-
the story for the arrest.
And I'm well aware, generally speaking, that Section 8 doesn't apply to civil cases. But in this city, I would make a qualification that it still applies in this case.
And what does that exactly mean, would you say, Your Honor?
I'm finding in this case that Section 8 applies to both civil and criminal cases, meaning that just give me.
Basically means you can't
Yes.
testify yourself. Same as
If the individual wants to testify himself, he's more than able to, but that's on his accord.
Which
Not
bit of the
law.
Constitution is this?
It's the right to not self-incriminate.
Your Honor, that part of the legislation clearly states in a criminal case, this is a civil case. That
Sorry,
is
mate, your
exempt from
voice
the case.
boxes are crackling.
So, if I may, can I just offer two direct questions to the defendant, and if he should choose to answer them, that can disqualify his questioning?
Just give me 2 seconds. To the defense, do you wish to testify in this case?
I mean, how would cross-examination go down? Do I just ask myself a question? Like,
Your
how does that all work?
cross-examination would be your test. Yeah. What?
So cross-examination just wouldn't exist?
No. Hang on a second. Your Honor, in this situation, would his testifying? Would him testifying be his cross-examination if we were to question him after it?
The court will enter into a 5-minute recess while I quickly consolidate everything and come back with a decision going forward.
The court acknowledged the fact that the Constitution states that in the
We
criminal
are
case.
currently just figuring it out. Give me 2 seconds.
What's part
Shit,
recess?
this is completely.
They got us on this one.
Yes,
They are correct. It does specifically state criminal cases. See, I thought they weren't allowed to do a cross-examination unless he was allowed. I mean, he could refuse the cross-examination.
Exactly. Because that what you sent me only applies if they themselves wanting to testify.
Or he can waive his rights. If he does waive his rights, he has no one to question him.
Exactly, that's the
So I'm not sure if it should be allowed. If there's no one to help stand for him,
exactly.
then it would not be fair in this case.
And I'm coming to the same conclusion as you. What I might do, if you want, there's nothing we can really do, because anyone who we bring at this time is not going to be on the same page.
Correct.
So we're going to put in. I might put in common law in this as well going forward.
It's probably a good idea.
Yes.
I'll co-counsel that one.
yeah, there has to be co-counsel if the individual, i.e. the chair or co-chair, wants to testify or is forced to testify. All right. We'll proceed as we were. If that's all right.
Yeah, that's good.
Would have been nice if he had a second officer with him.
The court has come to the conclusion, given the fact that the defense here does not have anyone to cross-examine him, we will not be allowing the individual, the chairman, the chair of the defense counsel, to testify in this case. A further precedence will be delivered during verdicts as well, the full common law that's going to come associated with it. Other than that, plaintiffs, any other witnesses you wish to call forth before this
Your Honor,
court?
we put a proposition for that one of the other members of police would be able to question him, but I understand your ruling already. But
I understand where you come from, but given the fact that the other officers or any other lawyer that we pulled in would not be able, that they're not up to speed on this case, their cross-examination would be nullified at most.
Your Honor, the plaintiff petitions the stand to potentially bring counts of perjury due to the fact that during the opening statement of the defendant, who is also the person being tried against, is not just the chair, but as said, the accused, claimed that he was attacked. We're accusing him. He apparently said that he directly said that my client attacked him and tried to punch him. There's been no evidence to prove otherwise, and that it means he's perjured himself in his opening statement.
I mean,
Just testifies it.
objection. There's no evidence from full stop. It's just he said, she said.
That is what testimony is, Your Honor.
I said, like I
The
recently
court will
read through it, had no
note
time to-
the court will note the motion by the plaintiff, and that will be delivered during verdict.
Just let it sit.
Very well. To the prosecution, do you have any other witnesses you wish to bring forth to this
No, Your
court?
Honor. The plaintiff rests on this matter. So far.
Very well. To the defense, do you have any witnesses you wish to put forth to this case?
No, Your Honor.
Very well. Could the plaintiff please approach the stand and deliver any closing remarks or statements in this case?
Thank you, Your Honor, and the other judge in this matter. As during this trial, we exemplified the facts of this case simply as my client was falsely arrested, which, as examined by Mr. Terra, and due to this fact, he has been negatively impacted on his mental health, as explained by the medical professional who gave his evaluation. During the arrest,
Objection.
you can't object during closing statements, Your Honor.
Sorry,
There will
mate,
be no
didn't know.
there will be no objections during closing statements in this case.
Yeah, sorry, Your Honor. Neither.
I might continue, Your Honor.
Yep, you may allow.
Due to my client's negative impact and due to the incompetence shown during the arrest, the fact it was negative, the plaintiff and we petition and urge the court that we find him liable and that we get financial reparations as well as mandatory retraining for the officer as well as a formal written apology from the Los Santos Police Department. That's all we require, Your Honor. Thank you for your time.
Very well.
Hey, mate. Closing statement. Honestly, just a he said, she said. They have no evidence. They keep on bringing up this PTSD thing, even though we cross-examined. It's because of the sirens, which has nothing to do with me. Yeah, old mate who said, Mr. Terra, said he didn't even see what I was even using. Also, didn't he say it was a bus away? No. Closing, yeah, done. 2 weeks. Thanks, Your Honor.
It is the decision of this court that the court will enter into an adjournment for 24 hours or 23 hours, reconvening at 8 p.m. Australian Eastern Daylight Time to deliver its full verdict and its full judgment in this case. Court is adjourned.
What's that mean?
Is he's with the 24 hours to they give their
24
judgment.
hours.
Okay.
What's the verdict, Sam?
All right.
That's a very right.
Yes.
We'll go.
24
we'll-
hours for no evidence.
What we'll
case.
do is
That's what testimony is.
Mantle.
I'll be
I reckon.
rereading of my notes that I took over the time.
yes.
But overall, now they were asking for $30,000 for damages. Is that correct?
That's correct.
Is
the
that-
offer? The offer was 30,000.
Oh, okay. So technically, we can change that amount if we deem fit.
Absolutely. No, that was just a settlement deal. Now we're in trial. It's up to us now. We can choose whatever the
Huh.
fuck we want.
So if we have a win for the plaintiff, this is just a hypothetical win for the plaintiff. We can say there was for injuries or reparations. For reparations, it'd be 20,000. For injuries and stress, like another 50,000, for example.
Yeah, we could.
And that has to go back to the police department, correct?
Yeah, we pay by the police.
Or is it the officer?
This police department. The case
Right,
is
all
against
right.
the.
Yeah, they definitely needed to get their own lawyer.
I've got a whole head written down too.
Yeah, look, I think another reason why this case was really
Oh, because of the shootout, apparently.
Yeah. I had a look in the MBT, you can see all the stuff going down.
Oh, yeah.
Look, I'm definitely inclined to say that the plaintiff had it their way essentially. The only issue would be
The officer calling, saying, "Hey, mate," to the bench was I almost stood up and started yelling.
Even
No, I think it's just temporary. It'll probably be lifted straight after this case, if not.
But yes, we'll need to the self-incrimination. It does say criminal case. He needed a second chair. There's no way around it. He needed a second.
One-time thing. But yeah, if you do want to attend tomorrow and you can attend, send us a message and let us know. Either one of us, it's fine. Otherwise we'll just, as soon as you're back in city, give us a call and we can catch up with you and sort everything out.
individuals who may be involved in the original case cannot stand to serve as a chair on a case going forward.
Mm.
At least from the police side, because it prevents things like this from happening.
Yes, definitely.
The police do have now have an in-city form.
And they were given ample notice. So there's, I know
they're
that
given 4 hours. No,
I know they had a raid, but that does not mean that they could not spare an extra officer.
exactly.
I mean, they had one walk in late. They had Gary sitting here. He could have stood a second chair.
Come on. Yeah, he could.
I think his name was Gary.
Yeah, I'm not. But even then, you're raising questions of whether a witness can just all of a sudden jump behind the counsel bench. Look, I reckon we draft. If you want to do it this way, we can draft up what we think separately.
Jesus, what the hell was that? Did you hear that?
I heard that. What the?
Was that lightning?
Yeah, it's like,
It's not raining outside.
yeah. But I'll be honest. I think in terms of I want to fix an hourly count in law for police for unlawful detainment.
Well, the thing is that we can award to the plaintiff. That's fine.
Yeah.
That's if we want to go that way. We can't force a member of the police to be retrained. We can only suggest that.
That's exactly what I was going to say.
We can't do that. It's up to police command. Yeah, it's up to police command to discipline their officers as they see fit. It's up to us. We just say that we can only suggest it, and then we can put that information through to leadership.
Exactly. No, I was about to bring that.
We can't enforce that at all, but we can enforce monetary for pain, suffering, reparations, court costs. I'm assuming that the lawyers are charging.
No, they are legal aid.
Oh, they're doing. Oh, okay, they're doing legal aid pro bono.
Yeah. Well, you just get paid by the government.
Yes.
I'm inclined to absolutely agree on that. I wasn't even going to consider forcing something because, again, it's a technical government agency. We don't have any.
We have no oversight. We only have oversight in the courtroom. That's it.
Exactly.
That's why if we are speeding outside the courtroom, we can't pull. Oh, I'm a judge, because that would be abuse of power, and we'd get in more trouble than it's worth.
Exactly. What I'm going to do is that we're going to create. I reckon we formulate separate case laws and we reconvene. We show to each other and we reason out what we want.
I like it. Yep.
Just gives two completely open perspectives on what we think we can.
Oh, you want both of us to present our own?
Oh no.
Oh.
We'll reconvene and we'll formulate one, but as long as they're completely separate ideas, it means that we're getting our honest views on the code.
Yes. That sounds good.
Very well. All right, we'll call it there.
All right, I'm going to head out, and I'll see you
Yeah,
8.
fine.
But what is it? 8 p.m. tomorrow?
8 p.m.
Yeah.
Yeah.
Which is 7 p.m. by my time that I fly in.
Yeah, that's fine.
Yeah.
Where to you, South Australia?
Queensland.
Oh, all right.
Yeah, it's
that's
sunny and rainy.
Oh, Melbourne was absolutely horrible. We were stormed in. I literally woke up by the sound of thunder fucking 2 doors down.
Oh, great. I actually sleep better during storms.
Really?
Oh yeah, I'm out like a light.
Shit.
Must be just like white noise.
Yeah, that probably makes.
All right, very good. I'm going to head out then.
Very well.
I think this is a very interesting case, and this sets a lot of precedent. So we've got to make sure we get it right the first time. Otherwise, last thing we want to do is screw it all up for everybody.
Yeah, exactly.
Maybe the Chief Justices might want to hear about it.
Oh, absolutely. Yeah. Well, I thought we'd doing this so they could get their input in as well.
Well, hopefully they will, but I know that they're not able to fly in for quite some time. So,
well, they'll be able to fly in tomorrow, so they get in tomorrow morning. So they have around 12 hours to review in emails at least of
yeah. Well, we'll see how it goes. Should be good. But yeah, I'm gonna go down to the pawn shop. I heard that they're actually buying metal detectors secondhand.